What you're about to see is a dramatization of a hearing conducted by the Kentucky Division of Unemployment Insurance Appeals Branch. In this example, an individual was discharged from her employment and was denied unemployment insurance compensation due to information provided by her former employer. The individual discharged is appealing and hopes to have the determination reversed. If you are ever discharged from your employment and are denied unemployment insurance compensation, you have the right to appeal that decision. This video will show you how appeal hearings are conducted and what information you may be asked to provide. For purposes of this video, all participants appear in person at this hearing. However, in reality, those involved often participate via telephone. While hearings like these are not conducted in a courtroom, they are legal proceedings that involve sworn testimony. As this example demonstrates, those involved most often include a hearing officer from the Division of Unemployment Insurance, who acts as a referee, a representative from the employer, and the separated employee. You'll notice that there are very definite and very established procedures which must be followed. These procedures are designed to allow both sides to present their viewpoints and allow the hearing officer to obtain the facts necessary to make a decision. Witnesses can be called to testify, and documents can be entered into the record as exhibits. As you'll see, documents to be entered must be provided to the referee and the opposing party in advance, and permission to enter any documents must be requested and granted. Either party may object to the entry of any document. Only evidence in the record may be considered while reaching a final decision. This is a dramatization. The names and the incident described are totally fictitious. The people appearing are actors. Any similarities to real individuals or an actual event are purely coincidental. Now, let's go inside and join the proceedings.
My name is Stephen Johnson. I am the hearing officer that has been assigned to hear your case today. The law requires that this hearing be recorded. I have a recorder on, and we are now on the record. The law also requires that all testimony be taken under oath, so I will place each party and any witnesses under oath prior to taking any testimony. Now, I'm going to place some background information on the record to include the parties present, the issue for the hearing, and the procedure we will follow, and then we will begin. Today is April 5th, 2012, and the time is now 8:15 Eastern Time. This hearing is being conducted with all parties being here in person. This is appeals docket number 12-00000A. The appellant in this case is Lisa Jones, and the appellee in this case is ABC Bank, represented by Greg Smith. The appellant filed an appeal from a notice of determination dated March 1st, 2012, which disqualified the claimant from receiving unemployment insurance benefits. Now, I will begin testimony with Mr. Smith. First of all, I will swear you in. Then I'm going to ask you some questions. You may answer those questions, and if there's any additional testimony that is relevant to the case, you may provide that testimony. Ms. Jones, you may then ask Mr. Smith any questions you feel would be relevant to the case. At that point, Ms. Jones, I will swear you in, ask you some questions. You may answer those questions. If there is additional testimony that is relevant to the case, you may provide that testimony. Then, Mr. Smith, you may ask any additional questions or provide rebuttal testimony that would be relevant to the case. Now, after all the testimony has been taken, we will move to the closing remarks section of the hearing. The closing is a brief optional statement you can make which would inform me of how you think I should rule and why. If you make a closing statement, there's no need to repeat any previously given testimony or provide any new testimony. Do either of you have any questions concerning the procedures or issues?
No.
Okay.
No.
Okay. Do either of you have any witnesses for today's hearing?
No.
No.
Mr. Smith, are you prepared to take the oath?
Yes.
Do you solemnly swear or affirm that the testimony you will provide in today's hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay. Ms. Jones, I'll go ahead and swear you in as well. Do you solemnly swear or affirm that the testimony that you'll be giving in today's hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
Mr. Smith, let's get started with your testimony. What was the first day of work for Ms. Jones?
July 1st, 2011.
Okay. And what was the last day worked?
December 31st, 2011.
What was her position?
Teller.
Rate of pay?
$14 per hour.
Was she full or part-time?
Full-time.
Okay. And was she separated due to a discharge, quit, or lack of work?
Discharge.
And who discharged her?
I did.
Was there anyone else present when you discharged her?
No.
And when did you discharge her?
December 31st, 2011.
Okay. What reason did you give for the discharge on that date?
I told her I didn't need her anymore.
And why didn't you need her anymore?
I walked by her workstation that day and saw a Facebook page on her computer monitor. And we have a policy about that, and I had warned her before about using her computer for personal use.
Did you confront the claimant?
Yes. She claimed she was not on Facebook and that someone else must have used her computer to access Facebook. She completely denied it.
Did you speak to any of her coworkers about the incident?
Yes. Her coworker Katie Adams told me that she saw her on Facebook that day too. I wanted Katie to be here today, but she's on vacation in Florida.
Okay. What is your policy about personal use of company computers?
Our policy prohibits the use of company computers for personal use, and violation of that policy will result in disciplinary action up to and including discharge.
How was Ms. Jones made aware of the company policy?
We covered it during new hire orientation, as it is in the employee handbook that she signed an acknowledgement for when she was hired. Also, I went over it again with her when I warned her about using our computers for personal use.
Has any other employee violated the policy?
Yes.
What action did you take after discovering the employee violated the policy?
I issued a warning.
You mentioned a prior warning for Ms. Jones. When was that?
October 29th, 2011.
Was it a written warning?
Yes.
Did you send in a copy of the warning for today's hearing?
Yes.
Did you send a copy to Ms. Jones 3 business days prior to today?
Yes.
Do you have any objection to the document being made part of the record for today's hearing?
No.
Okay. The warning will be marked as Employer's Exhibit Number 1. Mr. Smith, what was the warning for?
I saw her computer monitor on the QVC website, and she was apparently purchasing a set of Ginsu knives. I confronted her, and she admitted to shopping online while at work. I reviewed the policy with her and told her she would be discharged if she did it again.
I don't have any other questions for you, Mr. Smith. Is there anything else that factored into Ms. Jones's discharge that you haven't told me about already?
No.
Okay. All right. Ms. Jones, you now have an opportunity to ask Mr. Smith questions. Do you have any questions for Mr. Smith?
Yes. Mr. Smith, did you see me on Facebook on December 31st, 2011?
I saw your monitor on Facebook.
But my question is, did you see me at my workstation while the monitor was on Facebook?
No.
I don't have any other questions.
Okay. Ms. Jones, let's begin with your testimony. Do you agree with the dates of employment provided by Mr. Smith?
Yes.
Okay. Were you a teller earning $14 per hour in full-time employment?
Yes.
Were you discharged on December 31st, 2011 by Mr. Smith?
Yes.
What reason did Mr. Smith give you when he discharged you?
He told me he didn't need me anymore.
You heard Mr. Smith's testimony that he saw your monitor on Facebook on December 31st, 2011. Were you on Facebook on that date?
No.
How do you explain Mr. Smith's allegation that he saw your monitor on Facebook?
I don't have any explanation other than a coworker must have used my computer to go onto Facebook while I was away from my desk.
Were you aware of the company's policy regarding personal use of company computers?
Well, I signed a lot of paperwork when I was first hired, and I didn't read the handbook before I signed for it.
Mr. Smith testified that he covered the policy with you on October 29th, 2011 when he issued you the warning for using your computer for personal use. Were you made aware of the policy then?
Yes.
Okay. So let me make sure that I'm clear. Is your testimony that you were not on Facebook on your work computer on December 31st, 2011?
That is correct. I was not on Facebook on December 31st, 2011.
Did you receive a warning on October 29th, 2011 for using your work computer for personal use?
Yes, I didn't realize I couldn't use work computers for personal use during my break time. Mr. Smith gave me the warning and went over the policy with me. I haven't done it since being warned.
Ms. Jones, I don't have any other questions for you. Is there anything else you would like to add before I see if Mr. Smith has any questions of you? Mr. Smith, do you have any other questions for Ms. Jones?
No. She knows what she did, and she knows it was against company policy. We can't afford to pay employees to surf the net.
All right, Mr. Smith, do you have any additional testimony you would like to put on the record?
No.
Okay. In that case, we have reached the closing remarks section of the hearing, as I explained to you earlier. Each of you has an opportunity to make a closing remark. It is an optional statement as to why you believe I should rule in your favor. Ms. Jones, you get to go first.
I want you to know that I was not on Facebook on December 31st, 2011. Mr. Smith was just looking to get rid of somebody, and business was slow, so he chose me.
Mr. Smith, any closing remarks?
Yes. I think you should rule in the bank's favor because Ms. Jones violated the computer usage policy after being warned for the exact same thing. She knows she did it.
Thanks to you both for participating in today's hearing. You will receive my decision in the mail. If you disagree with the decision, you have the right to file an appeal. The appeal rights will be listed at the bottom of the decision. Read them carefully because there's a deadline to appeal if you wish to do so. Thank you both for your time. I hope you have a good rest of the day.
Thank you for viewing this unemployment insurance appeal video. As you can see, it's critical to be prepared for your hearing. Give clear and concise answers that are factual and can be confirmed with evidence. If you submit documents, be sure you send copies to all parties involved in the hearing as well as the appeals branch, and follow all instructions provided to you. The appeals branch is not responsible for sending your documents to other parties. If you plan on having a witness testify on your behalf, make certain they can provide direct knowledge or eyewitness testimony. All of this information and more can be found in your acknowledgement letter, which you'll receive when you file an appeal. After reading this information, if you still have questions, please contact the appeals branch at 502-564-3925.